Well, watch out, Elena Kagan, because you're about to get the gay prayed away, or the not gay, depending on if you believe the fact checks. But whatever the truth is, she will now be one of 9 Supreme Court justices to consider Colorado's ban on the practice. And this is going to be a fascinating case because it's actually not just about what sort of conduct consenting adults should be able to or have a right to engage in. We aren't just talking a ban on shock therapy or anti-gay brain surgery or something like that. We're talking about talking, actually, as in, does a counselor have a right to talk to someone seeking her counsel? No action, no physical intervention, just a discussion. And this case is a little more complicated than that because it's in the context of minors, but the same concepts still apply. Does a counselor have a right to talk to someone under 18 who is seeking her counsel, assuming parental consent? That's what the plaintiff in this case does. Kaylee Childs is a Christian state-licensed counselor in Colorado who believes that people flourish when they live consistently with God's design, an idea that of course applies directly to the issues of gender and sexuality. Now, is Childs patrolling around Westboro Baptist style, condemning strangers on the street as God-hated F-slurs? No. She makes a point not to impose herself or her views on anybody who's unwilling. She works voluntarily with clients who want her counseling, because they believe that her perspective is a viable path through their personal challenges. There is no capture here. There is no coercion. These are young people with very real problems who want to change their lives, and they believe that Child's counseling will help them do that. But the state of Colorado, like some 20 plus others, says no. That conversation, at least when had with a minor, is illegal, because that's not in fact a conversation at all. That is harmful conversion therapy. In 2019, Colorado amended its mental health practices law to prohibit conversion therapy for patients under 18. And yes, the definition of conversion therapy is anything that attempts to change an individual's sexual orientation or gender identity, including simple discussion, if the aim is to reduce sexual attraction towards an individual's same sex, even if that's what the individual wants. Childs doesn't even grant the premise that what she does is conversion therapy. She says that's mislabeling, and these are just conversations. But if Childs is caught engaging in these conversations, she'll face a $5,000 fine per talk, followed by suspension from the practice or revocation of her license. Destruction of her career, effectively, for saying words with which the state disagrees. With that core First Amendment issue at stake, you can see why the Supreme Court agreed to hear this case. Do you have a right to talk privately with consenting parties freely without government interference or coercion, or does that interaction become something else because it's in a professional context? That is Colorado's argument. Oh, this isn't even about speech, at least purely. It's actually about the regulation of professional conduct as states regulate in the medical context all the time. After all, just imagine the danger otherwise. Like if some quack doctor advised you to hack off your genitals in pursuit of insane gender ideology, for example. Oh, wait, never mind. That's perfectly legal and encouraged, actually, which is a big problem for the state in this case. But that is Colorado's argument. This law regulates conduct, not speech. And the speech that is involved is incidental, not central. The other reason the Supreme Court is taking this case, though, is because the appeals court circuits have conflicting decisions on that distinction. The 11th and 3rd circuits say that distinction is nonsense. You are regulating speech. You're telling the counselor what he can or can't say based on nothing but perspective. That is an unconstitutional First Amendment violation. The 9th Circuit, and now Colorado's 10th, through this challenge, disagree. They say there's no speech issue here at all. It's just the regulation of professional conduct. And so on Monday, the Supreme Court announced it has agreed to hear this case and presumably settle that dispute. In so doing, the court will consider whether that distinction makes any sense, but with just the quickest and slightest consideration of the facts, the distinction starts to fall apart. Just in layman terms, if someone asked you what the difference between speech and conduct is, you might say something like action. Speech is talking, and conduct is acting in some physical sense. And sure, there is some overlap, like if I encouraged you to commit a crime, for example, maybe I even help you plan out how to do it. Where speech is directly connected to an action in that way, maybe we do consider it conduct, but it still requires connection to some sort of act. What is the act connected to this speech? What is the act connected to the idea that maybe you're made in God's image just the way you are? Maybe the union of man and woman is the natural order of the world. Maybe you'll find peace and happiness if you embrace these truths. What is the action other than just accepting a belief? There isn't one. And the state doesn't even really argue that there is. In fact, the state's only distinction for why this speech is conduct is that the state disagrees with the speech. The perspective makes the difference. How do we know? Well, if this same counselor, Kaylee Childs, just changed her opinion and said, actually, men are women, as long as they say that they're women, and actually, a gay relationship is the exact same thing as a straight relationship, maybe even superior, that's fine. Counsel as many kids as you want with that perspective. No problem at all. License intact, career allowed. Colorado's distinction as to whether Childs is offering speech or conduct is just the content of what she says. It is only the opinion expressed. And if that is the case, if Colorado is assigning regulation not based on conduct, but based on viewpoint, the entire legal analysis changes. In deciding this case and accepting the conduct framework, the 10th Circuit Court of Appeals applied the rational basis test. If this is conduct, then there is no fundamental constitutional right at stake, and the only basis for review of Colorado's law is what's called the rational basis test. But that's a functional rubber stamp. Is there a legitimate state interest? Well, in regulating health services, yes. And does the law have a rational connection to that interest? Yes, this is simply defining the rules of the profession. If, however, there is a fundamental constitutional right at stake, as in a First Amendment speech right, well then what's called strict scrutiny applies. Strict scrutiny means the law is only valid if there's a compelling state interest, and in regulating healthcare professions, there almost certainly is. However, the compelling state interest must be pursued through narrowly tailored means, as in the most precise way possible, without unnecessarily infringing on that constitutional right more broadly. That is where this law will likely have some problems. Now, could Colorado say it's a problem to advocate for or prescribe certain actions they deem harmful, like shock therapy or anti-gay brain surgery? Probably. That is narrowly tailored in that it removes the regulation from matters of opinion and places it on advocacy directly connected to an action, like the concept of incitement. Colorado isn't doing that, though. They're saying if you express this viewpoint at all in a professional context, we're going to take away your license. That necessarily infringes on a particular perspective. So it's not narrowly tailored, actually. And that's probably close to the decision we'll get from these justices next year after they hear this case in the fall, not just because it's right on principle, but because this plaintiff, Kaylee Childs, is being smart with her approach. First, in a good legal team. The Alliance Defending Freedom is representing her, and they have a great track record of recent Supreme Court wins on similar issues. They won for Joe Kennedy, the high school football coach who was fired for private prayer on the field after games. They won 2 other major cases from Colorado: the web designer who Colorado tried to force to make gay wedding websites, and the infamous cake baker Jack Phillips, who Colorado tried to force to bake the gay wedding cake, though of course the court's decision in that case was much more narrow than the court could have decided on principle. The other smart play is the argument that this legal team is making. They are appealing directly to arguments that many members of this court have already accepted in prior cases. Probably the closest case the Supreme Court has already decided is National Institute of Family and Life Advocates, or NIFLA, versus Becerra, then the California Attorney General, decided in 2018. That case was a challenge to California law that required crisis pregnancy centers, which counsel women through unplanned pregnancies, to inform those women about abortions available at state-sponsored clinics. Hey, just so you know, there are free or discounted abortions right down the street. The state was forcing these crisis pregnancy centers to say that upon encounter with a pregnant woman seeking their services. So this Colorado case is about what counselors can't say. That California case is about what counselors must say, but the same principles still apply. California argued that because it was professional speech, the legal analysis changes. But the Supreme Court said no, Professional speech is not a First Amendment distinction. The speech is protected whether uttered by a professional or a layperson. And California made the same argument that this is about conduct, or treatment as they called it, and not about speech. But on that point too, the NIFLA decision also had a counter. You can't just rename speech treatment without some sort of meaningful distinction between the two, as that standard otherwise could prohibit discussions of any type in the medical context. How about, instead of a law requiring discussion about abortions, a law that says no discussion about birth control at all, ever? By this logic, well, that's just dealing with treatment, not speech, just the same. It's just a question of whether we like the speech or not, but that's not actually a distinction based on treatment or conduct. And these arguments matter on principle, but they also matter in practice because they're the same ones that Justices Thomas, Roberts, Alito, and Gorsuch accepted in deciding that California case against the state. And assuming they aren't just going to completely contradict themselves 7 or 8 years later, which actually might be a very big assumption, but assuming any level of consistency, just get Barrett or Kavanaugh to join, and this one is over too. Even more fundamentally, though, this case is a very interesting national pulse check, and I know it's not necessarily the same people involved in this case specifically, but in general, as a country, we are simultaneously arguing that physical sex change interventions for minors, surgeries, puberty blockers, etc., that is a constitutional right in which states cannot intervene based on no constitutional text whatsoever. That is a case the Supreme Court just heard in December, decision pending, but also simply talking to minors with parental consent about the alternative, like, maybe don't permanently alter yourself. Maybe God has a plan for you. Those words enjoy no constitutional protection, and any counselor who utters them should be banned from his livelihood. Action is speech, and speech is action, not based on any actual objective criteria, but just based on whether the ideologues want to ban the perspective or not. If you say it and they disagree, well, that's action with no protection. If they do it and you just say you disagree, that is also action with no protection. You can see how this is just a tool or a weapon and not a standard. And the Supreme Court probably will undo this particular piece of that nonsense, but of course that doesn't undo the underlying cultural crazy that's responsible for it. Ironically, a great way to start fixing that would be a sit down with a good counselor to talk about some godliness, actually, as long as there still is such a constitutional right to talk voluntarily in private. For now, we should all enjoy that until the entire world becomes a controlled script. Because, hey, at least for the moment, I am not required to inform you about the abortion you could be having at taxpayer expense instead of watching this video. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X, that is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Is live on Wednesday and Sunday nights. Looking forward to it. Hey, if you made it all the way to the end of the video, that means you probably found some value in the video. If you found some value in the video, please consider supporting my material. You can do that one time or recurring for as little as $1 a month. It not only helps me sustain, but it helps me pay the people who make my videos possible. Linked in the description for you, mattchristiansenmedia.com/support. Thanks for listening.